Mr. Adams.
May it please your lordships, I appear for the appellant. Mr. Pierce Smith appears as counsel for the first and second defendants. The third defendants do not appear. My lords, the appellant is extremely grateful to the court for making the time to consider this matter in advance of the proposed substantive hearing of the appeal. The appeal itself concerns the ownership of two family farms on the outskirts of Neath, Cefn Coed Farm and Crythan Farm.
I think I can cut you a bit short, Mr. Adams. We both looked extensively at the materials, so
I'm grateful.
We know what's going on. We've got a pretty good grasp of the history. I think it's probably going to be helpful for you to go straight to the points which seem to matter. First, do you already have permission to run the partnership asset point? Secondly, if you don't, is it open to the court, whether this in this constitution or in any other constitution, to give it to you now?
Yeah.
Thirdly, in the light of the answers to those questions, what do we do about your application for an extension of time and Lord Justice Lewison's order in respect of it?
My lord, yes. My lord, just very briefly, I may refer to the members of the family by their Christian names. No disrespect is intended. That's how it's been throughout. My lord, the position of the first and second respondents in this appeal is somewhat odd. But as I understand it, my learned friend will seek the same indulgence in this court as he did at first instance to appear on behalf of the estate and stand in their shoes for the purposes of...
I don't think this is a point that's been flagged in the materials. I really don't think we're going to be inquiring into Mr. Pierce Smith's standing on this hearing.
Well, my lord, my lord, you have the materials. And the starting point is, on any basis, we have limited permission to appeal. And what that means is that this court is seized in the matter, and it was inevitable that at some point this appeal was going to come before the court. And it's the appellant's basic case that, and this is perhaps dealing with the last point rather than the first, that the substantive appellate jurisdiction of the court as a court of justice is unlimited. And for justice, which has a universal meaning to be done and to be seen to be done, court sitting to hear the appeal must have jurisdiction to entertain argument on any issue which it considers properly arguable and which it considers it is necessary to determine in order to do justice in the appeal.
I'm inclined to think that's the second point rather than the last.
My lord, I'm tolerant. Well, my lord, it is the second point, yes. It possibly runs into the third point. My lord, and going to the first point then straight away, we say we've been given permission to appeal on grounds 3 and 5, and nothing that has happened subsequently or has affected that position. And if one goes to the order of Mr. Justice Lewison, which is Appeal Bundle 1, pages 83 to 84, tab 11. What we have,
Just in the hope that there is no confusion, I have the order at pages 81 to 82.
I apologise. My lord, it is 81 to 82.
That's all right. So long as we don't have
get
different.
the first reference wrong. My lord, what we have is it's entitled Order made by Right Honourable Lord Justice Lewison. Over the page, it is signed Lord Justice Lewison by the court. This is something done by the Court of Appeal, big C, rather than a court, small c, and it is done by the delegated power, by the power delegated to the single Lord Justice under the rules, in accordance with the rules.
I haven't quite understood the significance of the word delegate. The court is a court with many judges, 39, I think, ordinary judges and various ex officio judges, but it doesn't sit as the entire body ever. It sits either as 3 judges or 2 judges or 1 judge, and it sits either in a hearing in a courtroom or to decide things on paper. I don't understand the significance of the word delegation, which I think from your skeleton you put some reliance on.
Well, my lord, I think, and we do place some reliance on that, because, my lord, it only sits in court.
Does that
And
matter? I mean, it clearly, clearly makes decisions on paper, and it's clearly entitled under the rules to make decisions on paper, and this is a decision of the court. It says so, and it is. I mean, why is it not a decision of the court?
Well, my lord, there are two. That is because the court is used in 2 different meanings in the legislation. And
you'll have to explain that to me, because I've not understood this point, and I think.
Well, my lord,
it's a point you place some reliance on.
It is a point I take, and my lord, I've dealt with the submission, the statutory provisions in paragraph 5 of my skeleton argument for this hearing. And my lord, it's if one has to start with the Senior Courts Act,
yes,
1981, and my lord, this of course used to be known as the Supreme Court Singular Act, because under the Judicature Acts, the entire jurisdiction of the predecessor courts of unlimited jurisdiction were transferred to a single court which had 2 divisions, the High Court and the Court of Appeal, and that's reflected in section 1. Senior courts of England and Wales shall consist of the Court of Appeal and the High Court Justice, each having jurisdiction as is conferred on it under this or any other act. And my lord, that transmit the jurisdiction that was transferred to the courts under the Judicature Acts and includes any additional jurisdiction that has been given to the courts under statutory authority.
yes.
My lord, section 2, the Court of Appeal, big C, shall consist of, and my lord, it is all the judges that it's the ex officio judges and ordinary judges as defined in that section under section 1.1. And the supervision under 2.6 that the Court of Appeal shall be taken to be duly constituted notwithstanding any vacancies in certain offices. So the Court of Appeal, big C, is something that is constituted. It is an institution of some sort.
It's a way of describing the collection of judges who make up the Court of Appeal. Yes.
My lord, yes. Because,
that court, as so defined, never makes any decisions at all because, as I say, you never get a court of 40-something judges sitting together.
well, in my submission, it does by delegating its authority to officers and officials in accordance with the rules. And that is why at the bottom of the Lord Justice Lewison's order, it says by the court. And my lord, I will develop this submission because the jurisdiction of the Court of Appeal can only be exercised by the judges in court. And that is a point I'm going to come to. Because, my lord, if one goes on to section 15, section 3, there are two divisions. Then one gets to section 15 and the general jurisdiction of the court. And subject to the provisions of this Act, there shall be exercised by the Court of Appeal, capital C, all such jurisdiction, whether criminal or civil, is conferred on it by this or any other Act, and all such jurisdiction is exercised by it immediately before the commencement of this Act. That's the carry-through. And then if one goes back to 3.5, any number of courts of either division may sit at the same time. That's C, small c. And if one goes on to 54, and 54.2, start at 51.1. This section relates to the civil division of the Court of Appeal, and in this section, court, small c, except where the context otherwise requires, means a court of that division. Subject as follows: a court shall be duly constituted for the purposes of exercising any of its jurisdiction if it consists of one or more judges. And my primary submission is that the jurisdiction of the Court of Appeal as an institution is exercised by judges sitting in court.
Now, I'm not sure where you get the last bit from. I mean, on the face of it, what we've got so far is that courts of the Court of Appeal can consist of one or more judges.
My lord, yes.
It doesn't say anything about sitting in court.
Well, my lord, I think that comes from 3.5.
Well, that's facilitative.
Any number of courts may sit.
But that doesn't say anything about there being a bar on anybody making decisions as the court when not sitting.
Well, my lord, in my submission, when you're, and this is fundamental to my submissions, when decisions are made by anybody other than a judge sitting in court, it is an exercise of authority delegated.
Where's the delegation?
Under the rule. And there's a scheme of delegation, which I'll take you to, because there's a scheme of delegation not just for judges, but also for legally qualified court officers, those described as masters, those that are legally qualified either as or legal execs, and then certain powers are exercised by non-legally qualified officers, for instance, issuing proceedings.
So you're going to show us where you get the delegation from, but why does it matter? I mean, supposing that under the rules or otherwise, the Court of Appeal delegates to an individual judge the power to make a decision, and he makes the decision, why does it matter whether it's a delegation or a constitution?
Because, and my lord, this will need some elaboration, because it is a delegation, it is under the supervision of the court, and the court has an inherent jurisdiction to supervise its processes, either in accordance with the rules, or in accordance, or if the rules don't provide for any route of appeal under its inherent jurisdiction. I rely in particular on the B line of cases, which I've mentioned in my submissions.
So can I be sure I've understood where we've got to? I think you accept, as a result of section 54.2, that a single judge of the Court of Appeal sitting in a courtroom is exercising the jurisdiction of the Court of Appeal, not as a delegate, but just as a judge of the Court of Appeal, and hence as one of the courts in which the civil division can sit. That's correct.
My lord, yes.
But your submission is when the same single judge is sitting in his room and writing a written order dealing with an application on paper, which he has power to do under the rules, he ceases to be a judge of the Court of Appeal sitting as the Court of Appeal. He's some sort of delegate.
Yes.
And you say it follows from that it doesn't matter how much the rules say his decision is final, it's not.
My lord, in my submission, the rules don't say it's final. And if one looks at Section 54 of the Access to Justice Act in 1999, it's quite clear that the Access to Justice Act is only dealing with a decision of a court, small c.
Yes, but
and my lord, and I will go to the court. I will go to the rules because, and my lord, this case is very different from a case where there's been an absolute refusal of permission.
Okay, so if there's been an absolute refusal of permission, then I think the scheme of the rules is, generally speaking, you can't, an absolute refusal of permission on paper, you don't have a right anymore, as you did originally, to have that reconsidered as an oral hearing, because the rules, I can't remember, is it 52.24.6, exclude from your general right to have paper decisions reconsidered at an oral hearing a decision on permission. So if permission is refused, that is final. That is subject to 52.30, which requires the exercise of what's called the Taylor and Lawrence jurisdiction, which is a very limited and exceptional jurisdiction to reopen a refusal of permission to appeal. So, do you accept that in such a case, if permission is refused on paper by a single Lord Justice, then subject to bringing yourself within 52.30, that is that?
Well, my lord, I don't accept that, and this is an argument that's been run before and was run in Poe. But my lord, it's not strictly relevant to these proceedings. But what I say is that in those circumstances, since 2016, when the rules changed, there's been no right to an oral hearing. Because up till that point,
yes,
and from before and after 52.17 was included in the rules, there was a right to an oral hearing before a constitution, and it was only if there had been a decision taken by the constitution that it was accepted that 54.6 kicked in, and there had been a final decision. That was the practice. That was the practice of the court, And so
just pausing
in 2016,
there. Sorry, before you come to the implications of 2016, as you say, there had been more than one decision of the Court of Appeal pre the 2016 change, to the effect, as I understand it, that if you were granted limited permission and no more, that was that. Now, do you accept that that was the case before 2016?
Subject to the Taylor and Lawrence type jurisdiction. Before 2016, if there had been a hearing in open court with argument and the court had granted a limited permission, then subject to a change of circumstances that might bring in sort of jurisdiction under 3.17 or the ordinary principles of revisiting an interim decision, which in my submission are not excluded by and cannot be excluded by Section 54, then if it was a proper, then if there's no other basis for revisiting it, then you are bound by the Taylor and Lawrence jurisdiction under 5230. But my lord,
sorry, just before you go on, in terms of the qualifications you've built in there, bar the 5231, they're contrary, aren't they, to the Court of Appeal decisions pre-2016?
Well, pre-Court of Appeal decision pre-16 say that 317, they either say 317 is inconsistent with, you cannot go under 317, you have to go under 317 or 5230, which is 5217, now 30, or the jurisdiction under 317 should be exercised in a similar manner. But my lord, in my submission, 5217 wasn't included in the rules to narrow the jurisdiction of the court. It was included in the rules to codify the reserved jurisdiction to revisit final decisions.
Absolutely. So pre-2016, there was the safety valve of 5230 or 5217, or before the codification, the Taylor and Lawrence type jurisdiction. But the authorities were to the effect, weren't they, that was that. Absent that scenario, you were stuck with the limitation on the permission.
My lord, yes. That was the tenor of the authorities.
And indeed, the succession of Court of Appeal decisions that we would have been bound by.
Well, my lord, again, this court cannot alter by its own decision its jurisdiction.
Well, it doesn't really matter in a sense, because once this court has decided what its jurisdiction is, every subsequent constitution of the Court of Appeal is bound by the decision as to what its jurisdiction is. It doesn't matter whether you have a different construction of the statute. We are bound by what the Court of Appeal has decided.
Well, my lord, in my submission, I don't, for the position, the rules of court regulate the practice of the court. And any decision as to the interpretation of a rule is a matter of practice.
It's not, it's binding. The rules of precedent say the Court of Appeal is bound by its previous decisions unless they're per incuriam or whatever. So it really doesn't matter whether what the statute said or what the rules said, if there is a binding Court of Appeal decision on the point.
Well, my lord, in my submission, it does, because that's in tension with the well-established principle that the court cannot either give itself or take away from its substantive jurisdiction by its own decision. And that, my lord, is why the Gourlay principle applies in my submission. It is for the Court of Appeal to regulate its own processes under its inherent jurisdiction. And if it goes wrong, then it is for the court, primarily for the Court of Appeal, to revisit those decisions. And the court should not gloss the rules. Otherwise, one just gets a sort of iterative deviation, potentially, from what the rules meant. One gets hundreds of cases being cited in interim applications. And what matters are the principles to be applied and what the rules actually say. And one can wander off if one starts looking at cases decided on particular facts and particular interpretations. And in my submission, the court is not bound. And my lord, I hesitated when your lordship asked me whether I accepted that it was just 5230, because on its face, 5230 doesn't apply to limited permissions. If one just reads the words of the rule, because one has to bear in mind that the provisions under Section 54 of the Access to Justice Act 1999, the existing rules, predated 5217. And as I say, 5217 was only intended to codify the Taylor and Lawrence jurisdiction. And 5231 says the Court of Appeal, or the High Court, will not reopen a final determination of any appeal. Now, on any basis, a grant of limited permission is not the final determination of any appeal. No,
but appeal under sub-rule 2 includes an application for permission to appeal.
Yes.
And the grant of a limited permission is necessarily a refusal of permission on the other grounds. Why is that not a final determination of the application for permission?
Because an appeal can be finally determined by
No, not the appeal. The permission appeal in paragraph 1 includes an application for permission to appeal. So the question is whether, when the single Lord Justice on paper refuses permission on grounds 1, 2, 4, 6 and 7, they have finally determined the application for permission to appeal. Well, since it can't, under 5224(6), be renewed in open court, why is that not the final determination of an application for permission to appeal?
Well, my lord, I think one has to go back slightly to understand what this rule is, because if one looks at 52(1)(b), what this rule is aimed at is reopening the appeal.
Or application for permission.
But the appeal has only been finally determined under 5231 if permission has been refused. And otherwise, there's no appeal to reopen, because the Court of Appeal is still seized of an appeal.
I'm sorry, Mr. Adams, I don't understand this. I understand entirely that what's now 5230, previously 5217, was introduced to codify the Taylor and Lawrence jurisdiction, which was derived by the court from its inherent jurisdiction to deal with exceptional cases where, despite the fact an appeal had been dealt with, the court thought it appropriate to say this appeal can be reopened. On its face, 5230 applies to final determination of an appeal, but that is extended by subparagraph 2 to deal with final determination of an application for permission to appeal. Because appeal, in quotes, includes an application for permission to appeal. So you have to read 5231 as if it said, the Court of Appeal will not reopen a final determination of any application for permission to appeal, ...
And my lord, that then begs the question of what is an application for permission to appeal. And one gets some help with that from section 54 of the Access to Justice Act 1999. Because it is subsection 6 that gives the finality to the decision.
Where do we find this?
Tab 3.
Tab 3. What do you want?
Oh, 54.4. So, if one starts at 54.1, rules of court,
Yes.
and my lord, rules of court are different to the appeal itself. They only govern its process. May provide that any right of appeal, and that anticipates that, for instance, there is a right of appeal from the High Court to the Court of Appeal, may be exercised only with permission. So that and then one goes to and if one's going through this section, note capital C, capital A of the Court of Appeal in 1. And then under 3, purposes of subsection 1, rules of court may make provision as to the court or courts which may give permission for the purpose of this section, small c. And no appeal may be made against a decision of a court, small c, and this, for the purposes we were discussing just now, this is the important provision, to give or refuse permission. That is a binary decision whether to give or refuse permission. If there is a right of appeal, then the decision is, do you give or refuse permission?
I'm not sure why this matters, really. I mean, we're not concerned with whether there's a right of appeal against an order relating to an application for permission to appeal. There's no attempt to appeal that. There can't be.
Well, my lord, it isn't. The importance of it, my lord, is that there are some cases, and the case I'm going to take your lordships to next, which is important on these points, Yorkshire Bank and Hall.
That's pre-CPR, isn't it?
It was pre-CPR. It was also a case where there was only a right of appeal to the Court of Appeal with leave. So under the then section, I think it was 18(1)(a) of the Senior Courts Act, there were certain classes of case that there was only a right of appeal.
Interlocutory decisions and the like. Yes.
Yes, and decisions from the County Court, which I think that this was. And so there is no right of appeal until that decision has been taken. And then when that decision is taken, the extent of your right of appeal is what you've been given. Section 54 starts with the reverse of that. You start with a right of appeal to bring before the Court of Appeal any proper point that arises out of the judgment of first instance. And there is then in certain circumstances, a procedural bar to exercising that right of appeal. And my lord, that bar was set in a case called Smith and Cosworth, which was decided by Lord Wolfe in advance of the CPR. And he says when the power to refuse permission, and he emphasises the word refuse, will arise. That test was adopted in the Bowman report, as a result of which Section 54 was enacted. And
Can we just come back a moment to Section 54? You say 54.4. Well, 54.4 says you can't appeal. Well, that's not what we're dealing with, because
No.
there is no attempt to appeal. And then it goes on to say well, it doesn't affect a right under rules of court to make a further application. So it doesn't say there is a right, it's up to the rules of court whether there is or isn't a right. So it takes us no further, does it?
Well, my lord, there are various rules of court that are potentially applicable.
But 54 doesn't help us because we have to look at the rules rather than anything in 54.
Well, my lord, just that is the nature of the decision. We look at 54 for the nature of the decision as to whether or not that becomes final. And it is to,
what do we get about the nature of the decision?
That it is to give or refuse permission to exercise the right of appeal.
Well, in one sense, but you can't appeal against a decision of that kind. But I'm not sure where that gets you. It's perfectly plain under the rules that you can have a limited grant of permission.
And my lord, that leads us on into the question as to there is a rule you can have the issues in the appeal can be limited. There is then an issue as to whether that power is part and parcel of the decision to give or refuse permission to exercise the right of appeal, or whether it's a separate power.
But why does it matter? I really don't understand why it's of any relevance. I mean, under the rules, there is provision for the limited grant of permission. Why does it matter how you characterise that? That's what the rules say. Because
my lord, the starting point in any interim decision under the rules, any interim procedural position, does not bind the court or the parties finally. Phipson puts it in absolutely general terms. There is a developing jurisprudence under 317 and in relation to abuse of process that says that if there has been an adjudication, and it is emphasised if there has been an adjudication, in other words, there's been a decision in court.
No, sorry, why do you say a decision in court? I mean, this does raise a point that comes out of your skeleton. You've been taking us to matters relating to the Court of Appeal, but as I understand it, you also rely on Part 23. And is this your case, that whenever a district judge makes an order on paper, he is making an administrative decision which is not an order?
He has got delegated authority to make an order. Under the rules, you're entitled to have that reheard in court. Not reheard, heard for the first time in court.
But that's under Part 23. That's the general
Well,
rule.
under the rules, if a decision is taken, it's almost universal through the rules. If a decision, and it appears in different places, if there's an exercise of delegated authority on paper, then at the request of the parties, you're entitled to have it reheard in court. And that used to be the position when a lot of the procedural matters were delegated to masters, and one could always renew the application before a judge in court.
And that
yes, but that is gone. Yeah, I mean, decisions of masters are now decisions which have to be appealed, and you don't renew the application, you appeal the application. We can remember when we were young that you would start again in front of a judge if you would transferred a decision of master into a hearing before a judge. But now you have to appeal, and you need it's a review. It's not a rehearing.
Well,
and you may well be right that the general position under the CPR is that if you have a decision on paper, you have a right to have it looked at an oral hearing. But the one glaring exception to that is in 5224(6), which says it doesn't apply to an application for permission to appeal. So why does that not mean what it says?
Well, my lord, as a matter of process, if a delegated decision is taken, then either it can be reheard, which is the usual rule, or as with currently masters and high court judges in the high court, there can be a process of appeal. that's a matter of procedure. Or if the rules don't provide any route to bring it before the court, which has the responsibility for supervising the exercise of all delegated jurisdiction, then the court can exercise its inherent jurisdiction. And my lord, that's paragraph 34 of my that the court always has that jurisdiction. It's 34 in my hearing skeleton argument, and it's Beeline, which was another decision of Lord Wolfe, followed in Macro and Rimmick. Because the bottom line, we say, is that the jurisdiction of the court can only be exercised in a court.
Why do you say that?
Well, my lord,
I have not understood yet. I was just looking at the rules. And Rule 52.5 says, where an application for permission to appeal is made to the Court of Appeal, big C, the Court of Appeal, big C, will determine the application on paper without an oral hearing. And then there's a provision enabling the judge to adjourn it into court. Why is that not I don't understand why you say that's a delegated decision, and why it's not a decision of the Court of Appeal, big C. It's what the rules say. They say the Court of Appeal determines it on paper. And we know what the practice is. The practice is for a single Lord Justice to determine the application on paper. And this rule seems to me to provide that is a decision of the court. Why is it not?
The Court of Appeal has delegated its powers.
Why do we have delegation? We've looked at the statute which says the court can be one or more judges. Here you have one judge. It's very clear from 52.52 that it's contemplated that it's going to be one judge. I'm not sure why delegation would matter, but I don't see why there's any delegation. It's just how the court is constituted for the purpose of making this decision on paper.
Well, my lord, there is authority that it is an executive, not a judicial decision.
No, I don't think there is. You're relying on the Siddiqui case.
Yeah.
Well, it doesn't say that. Can we look at it? And it obviously isn't. It's a judicial decision.
Well, my lord, that I think is fundamentally at the heart of.
Are you saying that a single Lord Justice sitting in their room deciding an application is not acting judicially?
He is not adjudicating anything as a judge of the Court of Appeal.
Well, that I have a huge difficulty with. The rules seem to me to contemplate that that is precisely what a judge of the Court of Appeal is doing. He's deciding, determining an application on paper without an oral hearing, and the rules say not only that he or she can, but that that's the usual way in which the Court of Appeal exercises its power, jurisdiction, to grant or refuse permission. And I don't understand why the judge that does that is not acting judicially.
Well,
it certainly feels as if one's making judicial decisions when one makes those decisions. You don't just tick a box. They're carefully considered exercises of the powers under the rules. What is not judicial about that?
well, my lord, in my submission, under the I'm going to take my Lord Justice Newey to see.
I'm sorry, we ask you too many questions.
My Lord, if I can just park Siddiq and ask for a moment and just answer that question. The permission process is essentially a striker. For the reasons given in
No, I don't think it is. It's a gateway. You need to persuade. It's not a strikeout. The respondent doesn't make any application at all. It is the applicant who needs to persuade the court, either the lower court or the Court of Appeal, that his appeal meets the test laid down in the rules, and we've seen the statutory power to make rules, and the test is that there needs to be a real prospect of success or some other compelling reason, and we know, we're all very familiar with that. It is for the applicant to persuade the court, in the shape of a single Lord Justice, that his appeal meets that criterion. That's not a strikeout.
My Lord, it's a procedural power given to the Court of Appeal to refuse permission. And my Lord, still parking Siddiqui, my Lord, if we can go to one starts with Lord Wolfe in Smith and Cosworth, tab 23, probably in the first bundle of authorities. The court will only refuse, and he emphasises refuse, leave, is satisfied that the applicant has no realistic prospect of succeeding on the appeal. The test is not meant to be any different from that which is sometimes used, which is the applicant has no arguable case. Why, however, this court has decided to adopt the form phrase is because the word realistic makes it clear that a fanciful prospect or an unrealistic argument is not sufficient. The court can grant the application even if it's not so satisfied. There can be many reasons for granting leave, and if the court is not satisfied, the appeal has any prospect of success, and for instance, maybe in the public interest, etc. So the court only has power to refuse permission if there is no realistic prospect of success, but can still grant permission even if it doesn't consider there is prospect of success.
Well, that's obviously under pre-CPR. We now have to look at the CPR. But yes, I understand.
Well, my Lord, that has been adopted post-CPR in a case of Tanfern, which is also in the bundle. And my Lord, the process of permission to appeal is intended to be a summary process. It is not intended to be a careful decision of the court.
Well, those two are not inconsistent, Mr. Adams. Every decision, granting or refusing or limiting permission to application, is carefully considered.
Well, my Lord, that may well be the case, but I'm saying just as a matter of principle, under the rules, and it happens in this case, you're only allowed to put in a limited amount of material. You're not expected to work up your full appellant skeleton argument, because otherwise that would defeat the point of refusing permission. The parties are only going to incur substantial costs on the appeal, or the substantial costs of preparing the appeal if they get permission. It is intended to, it is a summary process at the outset. It is a procedural filter that, as I think Lord Hoffman put it in case will come back to me, that was mentioned in Pope. It is to weed out not just hopeless cases, but also cases with no realistic prospect of success. And I put the case of R on the application of Wasif in the bundle, because that tries to explain how there can be a difference between a case with no prospect of success and one totally without merit. There is some ground between totally without merit and no realistic prospect of success.
But again, we don't need to go into that, do we? That's irrelevant for our purposes.
Well, my Lord, the nature of the application and the decision is relevant for our purposes. And my Lord, that in my submission is the nature of the application. If one, my Lord, I'll take your Lordship now to Siddiqui, which is in the probably the third one, of course. It's a reasonable.
Tab 55.
Post the. My Lord, in particular, it's paragraph 17. And my learned friend makes much of the first sentence about the fallacious nature of Mr. Davison's position. This was an ousting prevented access to the court. And my lord, this was a case decided by Sir Timothy Lloyd. I think at some point he does mention that the entire Court of Appeal at that time agreed to the introduction of the rule. It seems to proceed on footing nothing less than the closest possible examination to approximation of perfection. The process of filtering appeals can satisfy Article 6.
So here there was a challenge to the process.
Yes.
Under either Article 6 or the common law right of access.
Delays in the hearing of appeals do cause injustice, I think principally an Article 6 challenge, as explained in the interim and final reports. Given the constraints on the number of judges, a balance has to be struck in the modification of procedure for permission to appeal to reduce so far as possible delays in hearing determining appeals. And my lord, I readily accept that the primary obligation of the Court of Appeal is to decide substantive appeals. Its time should not be unduly taken up deciding summary with applications in relation to permission. That, it seems to me, is a paradigm case for the exercise of an executive decision within the range of the margin of appreciation as to how to ensure a proper, fair and efficient system for the administration of justice in civil appeals.
So the executive, or indeed the legislature, had a choice as to how to set up the system. There was a margin of appreciation as to how to ensure a proper, fair, just and efficient system. That was the executive decision. There was a choice to make as to how you set up the system.
Well, my lord...
This was a challenge to the system. Sir Timothy Lloyd is saying there was a margin of appreciation as to how you did it. This is all right. It's not saying anything about an individual decision.
Well, my lord, I think what he's saying, this is case management. This is rules of procedure. It is within the walls, as I think is put in Sillam, of the appeal, which is something different. And he goes on to say, the reason, and it is therefore, it's an executive decision to make the rule, it is also giving, the rule gives the court executive power.
It doesn't say that at all.
Where does he say that?
In the present proceedings, he had a consideration on paper followed by an oral hearing.
Yes.
And had the opportunity to put the matter before the court. In the final sentence, the only issue is as to whether there would be an unfettered right to an oral hearing after consideration on the papers, or there would be a more nuanced position secured by the present rule under which an oral hearing may take place, but it is up to a member of the Court of Appeal, considering the papers, whether it does.
Up to the member, not a member.
Yes.
Yes.
Because, my lord, this is something I briefly touched on in my Cefn argument. The judge looking at it has to decide whether or not it can fairly be decided on paper. If he has any doubt in the matter, in my submission, he ought to be adjourning it into court.
But again, this is irrelevant for our purposes, isn't it? Because Lord Justice Lewison evidently did think it was appropriate to decide it on paper, so who cares whether he had a discretion as to do something to do something different?
Well, my lord, that is a decision in my submission which can always be supervised by the court. Now, supposing Lord Justice Lewison had refused permission altogether, for the start, then, and he'd done that on paper, it is right that the rule that is primarily applicable is then 5230. 5230 is a two-stage process. One first has to make an application under 5234 for permission to bring the matter before the full court. And in a sense, that's a second Lord Justice looking over the shoulder of the first Lord Justice. If they think there's anything in it, they can give permission for the court to look at it. It is only that decision, the decision under 5234, from which an appeal is precluded under 5237.
Sorry. Again, honestly, I really don't think this matters for our purposes, but since you say it, let's just understand it. So there's some scope for an appeal, is there, in relation to what happens on an application under 52.30? Is that the suggestion?
Well, there is no statutory bar to an appeal. It may be that an appeal wouldn't be entertained on Lane and Esdale grounds, but or else it would become a. But if one looks at 5230 carefully, permission is needed to make an application under this rule to reopen a final determination of an appeal. And again, one is talking about the final determination of an appeal, and it's difficult to read that as incorporating a limited permission, because that is not a final determination of an appeal.
No, but it's a final determination. We've had this argument of an application for permission to appeal.
Even in cases where under Rule 5231 permission was not needed for the original appeal, and there's no right of appeal or review from the decision of the judge on the application for permission, which is final. So, second judge looks at it. They check the homework of the first judge. If they think there's nothing in it either, then that is an end of it. It is that decision is final under 5237. But you're entitled to make the application under 5234.
And just so I'm clear what you're saying that the decision made under 52.34 is susceptible to appeal?
No. Well, the decision under 5234 is it's like a judicial review permission. Either you the judge looking at it under 5234 thinks there's enough in it for it to go before the court, or they don't. If they don't, then their decision is final. So you cannot get before the court. There is an absolute bar of getting before the court. But that will be because two judges have looked at the papers.
Well, actually, it's normally the same judge.
Well, my lord, my submission, that might be problematic in that if there wasn't additional material. I suppose there's an opportunity to put additional material before the judge. But
it is normally the same judge.
But if there was a challenge to the way that the first judge had exercised their decision, then they clearly couldn't be judged in their own cause. It would have to go before another judge. Would be my submission. But my lord, and if there's any, it's at least an opportunity to put further material before the first judge. But if not another judge, and if they think there's anything in it, then it goes before the full court. And it's my submission that once the full court has it before it, exercising the jurisdiction of the Court of Appeal, if there has not been a final adjudication in the appeal, which there necessarily won't have been in relation to an interim application, an application for permission, then the obligation of, and my lord, where I will ultimately get to is what Lord Halsbury said in Lane and Esdale. How can a court review a decision on permission other than consider for itself whether there's any merit? And one's talking about here a right of appeal, because my lord, that is
a right of appeal, which by statute can, and by the rules has, been restricted to cases in which you have permission.
my lord. Yes, my lord, it is of my submission constitutional importance that it is only the judges of the Court of Appeal sitting in court that exercise the powers of the Court of Appeal, and
sorry, that obviously is a punchline. I'm not aware of seeing anything so far that says that the powers of the Court of Appeal have to be exercised sitting in court. What is the key point I should take away on that issue?
Well, my lord, my lord, there is, insofar as there are the fundamental principles of set out in cases like Scott and Scott, that a court sits in public, and if it doesn't sit in public, its proceedings are a nullity. It's difficult to fit that.
So any decision made in chambers by a district judge working through his box is a nullity?
No.
Because it's not in court?
No, it's an exercise of delegated authority which is subject to the supervision of a court. But a court must, unless justice demands, sit in public. And that's reflected in the provisions of the CPR, because there are only very limited circumstances in which an application could be heard in private, and that's provided for in the CPR. And if one looks at CPR 23, the language of CPR 23 is it defines an application as an application made to a court.
We better just look at this.
Yes.
This is the new version of CPR 23, isn't it, in the supplement of the White Book?
Your Lordship is ahead of me there.
If you're going online, you probably don't need to look at the supplement, but those of us working from paper, this is the supplement.
My Lord, I hope I'm up to date. It's the 2023 consolidated version. Application notice in 23.1 means a document in which the applicant states their intention to seek a court order. And it's their intention to seek a court order. An application is made to a court, and the jurisdiction of the court is exercised in open court.
Doesn't say that.
Well,
in fact, 23.8 says the contrary.
Well, 23.8 then says that the application could be dealt with without a hearing.
Can the court make an order on that occasion?
By its delegated authority, yes.
Where's the delegation?
Well, the court there means capital C. It's not a court sitting. It is the court, capital C. So the High Court in the High Court, or the Court of Appeal in the Court of Appeal. May deal doesn't say decide the application or hear the application, because of course it's not hearing the application.
It isn't hearing it, it's deciding the application.
And the rules say applications which may be decided without a hearing.
The court decides the application without a hearing under paragraph 1C and does so without giving the parties an opportunity to make representations, then party affected may apply to have the order varied or set aside, and an application under paragraph 3 shall be considered at an oral hearing unless the court decides and states in order that the application is totally without merit. And my lord, that fits in my submission with the scheme of the rules. And in my submission, it would be ultra vires the rules to exclude the supervisory jurisdiction of the court.
Can I, before you get to that point, can I just be clear what you are and aren't saying? First of all, do you accept that where an application notice has been filed, it is open to a district judge sitting in his room to decide it?
Yes, he decides to deal with it without a hearing, and then he decides it. He makes a decision. He has authority to make that decision under the rules, but he is not sitting in court, and there is no adjudication of the application.
Now, why is there no adjudication of the application? The application says, can I have an order for such and such? The district judge thinks I can deal with this without a hearing. He makes something called an order.
Yes, he does.
That's an adjudication.
No, he has made an order, and he has power to make an order of the court, by the court, as per Lord Justice Lewis.
And why isn't that an adjudication?
Because an adjudication requires the court, sitting in public generally, to hear the parties and
what's the authority for that? I mean, you don't get that.
Well, my lord,
23.8. 23.8 says the court can decide something without a hearing. It's perfectly clear that it can make orders on that occasion. Making an order is a judicial decision. So why isn't it a judicial decision?
Because it is not a court, and the jurisdiction of the court is only exercisable by a court.
Well, it says the court may deal with the application without a hearing. So it is the court.
That's the court.
The district judge sitting on his own is the court.
He is Court Big C. He is the High Court. He is all the judge. But the High Court, under the Senior Courts Act, is the judges of the High Court. He's not a judge of the High Court. He has been delegated authority by the judges of the High Court under the scheme of the rules to exercise their collective procedural power as defined under the rules. That application can only be adjudicated in court by a judge exercising the jurisdiction of the High Court.
To be clear, there is no authority for that, is there?
Can I be sure that I understand this suggestion that the court means just the judges? CPR 2.4 says where these rules provide for the court to perform any act, and unless an enactment, rule, or practice direction provides otherwise, it may be performed by any judge, master, registrar, or district judge. So the rules use court to include district judges. Why then does 2.8 simply not mean a master, registrar, or district judge may decide without a hearing an application? Why is that not a decision?
It is a decision.
It is a decision,
but it's not an exercise of the. My lord, I think in a sense it's going back to first principles as the difference between a procedural power given by rules and the exercise of the court's substantive jurisdiction.
I don't understand this distinction. I understand that a court has a jurisdiction. The jurisdiction of the Court of Appeal is to hear appeals and so on and so forth. That has to be exercised by people. And the people are the judges of the court. And we see from 2.4 that under the rules, the court's jurisdiction can be exercised by all sorts of people, judges and registrars and masters and district judges in the High Court. And in the Court of Appeal, judges of the Court of Appeal, as well in fact as masters, can make judicial decisions. The distinction between, you're seeking to draw between how the court does its business judicially and what its jurisdiction is. In one sense, obviously there's that distinction, but I don't see that any consequences flow from it if under the rules the distribution of business is such that a judge, in this case a Lord Justice of the Court of Appeal, is given under the rules authority to make decisions of the court on paper, which is precisely what 52.5 does. It seems to me to be an exercise of the court's jurisdiction by the court in the shape of a single Lord Justice.
My Lord, I think the answer, or the answer that I would give to that, is that the rules of court cannot oust substantive jurisdiction of the court.
They don't seek to do so. What they seek to do is distribute the exercise of that jurisdiction among the various organs of the institution.
It is
in this case, they distribute the power under statute, under the rules made under statute, to give or refuse permission or limit permission. They distribute that, which is a power conferred on the Court of Appeal, to a single Lord Justice sitting without a hearing, unless they consider it can't be fairly determined without a hearing. Why is that not the exercise of the jurisdiction of the Court of Appeal by the Court of Appeal?
Because in my submission, the Court of Appeal cannot delegate its substantive jurisdiction to anybody other than a judge of the Court of Appeal sitting in court.
And what is the basis
Well, my Lord,
for that submission?
Well, my Lord, we've already looked at the Senior Courts Act that talks about the exercise of the jurisdiction of the court by judges sitting in court. In my submission, that is the only circumstance in which the substantive jurisdiction of the court can be exercised. The rules, my Lord, I'll take you to some of the early cases on this. Rules of procedure regulate what was previously the court's practice. The court has an inherent jurisdiction to manage its processes for the practical administration of the case in order to get it before the court, for the court to hear the substantive appeal. As was said in Cefn, I think I've cited this passage in my skeleton argument, if I can find it. And I'll just before I go to Cefn, obviously the court, as has been held in cases like Connolly and Bremer-Vulcan, it is inherent in their constitutional function as courts of justice that inherent in their substantive jurisdiction, and this is paragraph 5.7 of my skeleton argument, it is inherent in their substantive jurisdiction. They have powers to enforce their rules of practice, to suppress any abuses of their process, and to defeat any thwarting of their process. The court is responsible for its processes, and that is ancillary to its substantive jurisdiction. My Lord, if one starts with Cefn, this is a case about whether or not the rules...
This is tab 10.
Tab 10, yes. It was a case about whether the rules could give a right of appeal, and it was these were rules not made with statutory authority, and it was held that internal 7, bottom of the page 1207 of the English reports, internal 720.
You need legislative authority.
You need legislative authority. The court from which the appeal is given and the court which it is given must both be bound, and that must be the act of some higher power. It is not competent to either tribunal or to both collectively to create any such right. And just pausing there, my lord, that reflects my submission. The court cannot, by its own decision, either give itself jurisdiction or take it away. The court has a certain jurisdiction, and if it purported to decide that it didn't, then that would necessarily be per incuria, because the court, by its decision, cannot alter its own.
You definitely don't get that from this. But anyway,
my lord,
let's keep going.
It's an aspect of it.
All this is saying is, if there's to be a right of appeal, it has to be created by legislation.
And the power to regulate the practice of the court does not involve or apply any power to alter the extent or nature of its jurisdiction.
That's right.
And my lord, my submission that is right. Therefore, you need legislative power. And my lord, I'm just looking for the.
It's on page 1209.
Yeah, I'm just getting. And this is dealing with the powers of the judges to make rules of court over the page at 1209. Taking the word practice halfway down as equivalent to the cursus curiae or regulations of proceedings within the court itself, then there's the question of whether that is what they're doing. The mode of proceeding may be regulated partly by the practice of the inferior and partly by the practice of the superior tribunal, but the appeal itself is wholly independent of these rules of practice. And my lord, that is drawing the distinction between the substantive appeal, to which the rules of practice can serve, and any rules of practice and procedure. Because if the otherwise the procedural tail can wag the substantive dog. So it's then a question, and my lord, perhaps in that volume I'm going to also look at Flower and Lloyd, which is tab 13. This was a case where the appeal had been finally adjudicated, and there was an application to the Court of Appeal to set the judgment of the Court of Appeal aside on the basis that it had been procured by fraud, and it was held that the Court of Appeal had no jurisdiction to rehear the appeal, but an application could be made to a court at first instance to set the judgment aside for fraud. And page 299, Master of Law, the Rolls, George Jessel, perhaps unfamiliar with practice being regulated at all, halfway through the marked passage said, in the first place, it must be remembered that the old practice remains where not interfered with by the new rules. And secondly, it must be remembered that all the jurisdiction of the old Court of Chancery is transferred to the High Court of Justice. And my lord, that's exactly the same with the Court of Appeal, and that's explained at the passage over at page 300. Now we look at 4th and 19th sections of the Judicial Act. It's plain that this court is simply a court of appeal and nothing more. It has very large powers conferred upon it with reference to disposing of appeals, but beyond that it has no jurisdiction. Then he cites how the Supreme Court should consist of the two permanent divisions, and how, as originally enacted under the Judicature Acts, Her Majesty's Court of Appeal shall have and exercise appellate jurisdiction with such original jurisdiction as hereinafter mentioned as may be incident to the determination of any appeal.
How does any of this help you?
And that's a jurisdiction it still has.
If you want to apply to set aside for fraud, you have to do so at first instance. That's it.
But my lord, it is drawing the distinction between the incidental jurisdiction of the court and its substantive jurisdiction. The court has a substantive jurisdiction. Inherent in that substantive jurisdiction, if there were no rules of court, would be power inherent in its jurisdiction to provide for its practice. That practice can then be regulated by rules of court, interfered with, in the words of Sir George Jessel. But only, but that cannot and does not, in my submission, alter the substantive jurisdiction of the court.
Well, obviously, we're
now
25 minutes in.
Yeah.
I'm not clear how any of this relates to the two issues that particularly arise.
Well,
So the first two were, have you got permission to appeal already? Does any of this relate to that question?
well, my lord, this really all goes to the second question.
So
my lord,
can we then just focus for a moment on the first question to understand the case on that? So Lord Justice Lewison made an order originally which by his own account had a lack of a lack of clarity. Both parties said, well, what do you mean? He said what he meant, and then more recently in the order that you're now challenging, he said, well, if necessary, I'm correcting it under the slip rule. So it is your case, you already have permission to run ground 3. Why do you say that?
my lord, can I deal with that next? Because I was just going to take your lordship to Yorkshire Bank and Hall, which does draw the distinction between limited appeal and...
I suppose so, but Yorkshire Bank precedes the decisions post-CPR where the Court of Appeal said you cannot ask the Court of Appeal to give permission to appeal on a ground that has been refused. And those Court of Appeal decisions are inconsistent with the Yorkshire Bank case, aren't they?
No, they're entirely consistent, my lord. Because all those cases are pre-2016.
No, I follow. But
in every single one of those cases, there had been an adjudication in court.
So, but to be clear, Yorkshire Bank suggested that there was an untrammelled right in the court to enlarge the grounds of appeal. The subsequent Court of Appeal cases say no.
Well, my
so
lord,
if there's to be the sort of right you're talking about, it has to be because of the change in 2016.
well, my lord, I don't think Robert Walker does say there's an untrammelled right, because he says that where the court, the power, and this is sort of the idea has been developed in cases like Tibbles and things. 1725H says this power should be exercised sparingly because if it's already been considered by the full court, and in that case it had been considered by the full court twice, it would be very rare indeed for the appellant to be permitted to reopen the point.
And that's inconsistent, isn't it? The idea that it could be done at all is inconsistent with the subsequent line of Court of Appeal authority.
Well, my lord, what the subsequent line of Court of Appeal authority says, Section 54 says a decision is final, and those were decisions of the court. That was pre-2016. The difference is that
Now, I follow that, but
and
in terms of whether Yorkshire Bank helps us, Yorkshire Bank is inconsistent with that line of subsequent Court of Appeal authority.
well, my lord, I don't think it is, because 1725H effectively is reproduced, and what he says at 1725H is effectively reproduced in 5217.
So, well, in that case, it doesn't help us either because we're only concerned on that basis with 5230. So either it's inconsistent with later authority or it's simply dealing with 5230, and we know about 5230. It's not going to help us.
Well, my lord, the pre-CPR practice was that, and Yorkshire Bank and Hall explains why it is different where there's a limited permission to that, where permission has been refused altogether, and it is because the court is seized of the matter. And my lord, the other case I refer your lordships to, which is the closest case we have to my case, which is a 5230 case, is Soffler, where Mr. Justice Tugendhat, as he then was faced with a prior oral permission on limited grounds given by Mr. Justice Mitting, which he considered was wrong, and he exercised the jurisdiction which he said was recognised by 5217 to set that decision aside and give a further permission, and he did so on the basis that reflecting the cases I've put in about exceptional circumstances means no more than out of the ordinary run of cases, he said he could not see how justice could be done or seem to be done, and that is the important point about being in court, unless permission was given. My lord,
I mean, you're not actually applying under 5230 anyway, are you?
no, I'm.
So I'm not sure why any of this matters.
My lord, at the heart of my point is a very basic point. If the court, in exercise of its substantive jurisdiction to do justice in the appeal, is the final arbiter of what points are proper to raise in the appeal. And those issues can be raised, and often are, very briefly at the outset of appeal hearings. Sometimes the Court of Appeal thinks there's an issue that needs to be looked at, and there's a brief discussion about whether or not it's arguable, whether there should be an amendment to the notice of appeal, and it's dealt with very promptly at the outset of the hearing. And as was said in I think the Canavan case, leaving those sort of issues to the appeal hearing is cost effective. It avoids expensive and difficult applications.
I have to say, I'm not sure that the model of this case suggests it would be extremely uncost effective. You do not want to go into a substantive appeal not knowing what grounds are being run.
And my lord, that brings us back to what Lord Justice Lewison did or didn't do.
Yes, so the first question is,
my lord,
have you got permission to appeal?
Have I got permission to appeal? Yes. And my lord, if one turns up Appeal Bundle 1, tab 11, then we have Lord Justice Lewison's decision, and in the box at the top it says granted on grounds 3 and 5, refused on all other grounds. And on the basis of Smith and Cosworth, and that this is an exercise of a power by way of procedural filter to limit the issues in the appeal by refusing permission on certain grounds. The only ground 3 is not a ground that has been refused. End of. As the Lord Chancellor said in Lane and Esdale, this is not in any ordinary sense an order of the court.
I don't understand I mean, Lane Lesdale was a long time ago, but why is this not an order of the court? It says it's an order of the court, and we've seen 52(4) says that the court's power is to be exercised by a single Lord Justice.
It's for the reasons given. It's for the reasons given by Lord Halsbury in Lane Lesdale, tab 14. This was a case where there was only an appeal with leave, but the nature of the decision, apart, in that case, it was to give permission, but in my submission, it's a little different if it's to refuse. My Lord, it's the first marked passage, page 211. The words used are leave of the court, and although it may be that in some sense the leave of the court, whether it is given or withheld, becomes an order, I will not stay to discuss. That is not the ordinary mode in which it would be described. It is something done by order of the court. It is not an adjudication of anything. It is something done by the court. It either gives permission or it refuses it. It's an act of the court.
I mean, if one reads on, one finds that the judges attach importance to the particular context. They're not really trying to lay down a general rule. But leave aside whatever the position was in relation to this statute in the 19th century. What you get from the Court of Appeal is something headed order, which indeed may contain provisions as to costs. Are they not an order?
Yes, but they're not part of the order. They're not part of the decision to give or refuse permission to appeal.
I mean, the significance of this is it simply whether you can apply 40.12 to a decision granting or refusing permission. Is that the point?
Well, it's both goes to the slip rule and whether or not this is something that if the Court of Appeal is still seized of the matter, it can read.
Well, no. At the moment, we're on the question of whether you've got permission.
Yes. And my Lord,
so the only significance in terms of whether you've got permission is in relation to the slip rule.
My Lord, yes. And
taking you out of your course, so suppose...
well, my Lord, I probably easier if I find the right place in my submission.
Suppose there'd been a typing mistake in this document, and it had said, granted on grounds 1 and 2. Would that be susceptible to being corrected? I mean, would it be the case that you had been refused permission on ground 5?
Well, in my submission, what the court has done is recorded in the. It does it by order.
So you would have been refused permission on ground 5 if Lord Justice Lewison had made a mistake and written grounds 1 and 2 rather than ground 5.
Yes, and the judge looking over his shoulder under 5230 would say immediately something's gone wrong here, and give permission for it to be heard in open court.
So, I see, no power to correct under the slip rule.
My Lord, no, and there's a reason for that, my Lord, because the reasons are only given for the benefit of the party.
No, sorry, but that's a different question. The question is there power to correct what is headed in order under the slip rule? Why shouldn't there be?
Because,
it's obviously convenient.
Well, my Lord, the difference, the slip rule only applies to orders drawn to perfect my lord, in my grounds review, I said give effect to, but I didn't mean give effect to it. To perfect the judgment previously given of a court. The court
Where'd you get that from? I'm looking at the slip rules. 40.12. The court may at any time correct an accidental slip or omission in a judgment or order. So the only question is whether the document signed by Lord Justice Lewison and sealed by the Court of Appeal is an order, which is what it says it is on its face. Why is it not an order?
For the reasons given, my lord, I can't go beyond for the reasons given by Lord Halsbury. It's something done by the court. It is not the order that 4012 is referring to is an order that is drawn to record an adjudication previously made by a court. It is an administrative act. The court can therefore, under the rules, procedurally and administratively correct the order to accord with what the court has already done.
Well, Lord Justice Lewison must in his own mind have decided what he was going to do. Does this document give effect to what he had decided he was going to do?
It does what it says it does. He did it, or rather the court did it, by the court when it attached its seal to this order.
And does it contain an accidental slip? I mean...
Well, my lord, it doesn't, no.
Well, you say it doesn't, but Lord Justice Lewison, who ought to know, said it did, and indeed he said it the very next day or two after. So that wasn't what I meant.
Well, my lord, he said two inconsistent things, I think, if one looks at the consecutive emails. Because he confirmed to us that we had permission on grounds 3 and 5, and he told the respondents that it didn't include...
yes, as my lord said, there was a lack of clarity. But it has now been clarified. But this prior point of yours, which is that there is simply no power in the court to, under 40.12, to correct the bit of paper sealed by the court which refused permission on most grounds and granted limited permission. You say that's not an order. I have great difficulty.
Well, my lord, the reason the court cannot do it is that 4012 is a process of rectification. Objectively, one can look at what the court has done, one can read the judge's judgment, and can construe the judge's judgment and see whether or not the order
Gives effect to
well, not
the reasons expressed in the judgment. Well, why is that not exactly the same with this determination?
Well, it doesn't give effect because the effect arises from the judgment already given by the court.
Well, what happens?
It formally records what is the adjudication the court has already made.
And what happens with this application paper process? Determination, which is the words used by 52.5 on paper without a hearing, is the judge sets out what he is deciding in the box at the top, and then he sets out his reasons. That's exactly the same as when he hands down a written judgment after a trial and an order is drawn to give effect to it. The thing in the box is meant to reflect his reasoning, which he sets out his reasons. In this case, we know from the reasons that he limited it to the question of beneficial interest. Now that was unfortunately not as clear as it might be, because you could say, I think you do say, well, ground 3 is about beneficial interest as well. But that wasn't what the judge meant. And that's why Mitchell Morse went back to him and said, well, can we be sure what you meant? And he said, yes, I didn't mean it to include the partnership grant. That means that the box in the top did not reflect the reasons in the rest of the document. Why is that not exactly the same as an order drawn up by the parties or by the associates or by the judge him or herself to give effect to his judgment, which contains an error? In this case, Lord Justice Lewison says, it did contain an error. I didn't mean to give permission on ground 3. I don't see what's wrong with him doing that. You say he just can't do it.
Well, my lord, because this is, whether you call it an executive or an administrative decision done by the court, and one can look at I put the cases in like North Range shipping, which say the only reason that the reasons are given for this sort of decision is because Article 6 requires it for the benefit of the parties, and as pointed out in North Range shipping, the trend of administrative law is towards giving reasons for decisions. If reasons are not given, then it is difficult to review that decision.
Is it ever possible on your case to use the slip rule in relation to an order made without a hearing?
Well, my lord, if this court is looking at this matter afresh, and it's considering just unpack that. If a district judge makes the order on paper and he really realises he's got it wrong, he can always change his mind. He can go under 3.17.
So you can't, just the district judge who has stuck in the wrong date cannot correct it under the slip rule.
But he can do easily under 317.
Well, why not the slip rule? I mean, the slip rule is what's there for correcting accidental slips. That's what it's for. It's not, which is what 3.17 is for. It's for reconsidering something because you might have been misled or circumstances might have changed or whatever. That's not what the slip rule is for. The slip rule is for correcting accidental slips, which is what it says. My lord's question is, suppose there is a perfectly plain case of an accidental slip in an order drawn up without a hearing. Why can't it be used?
I'm sure
it depends what, I suppose it depends what that order does. If it's just got a date wrong or something, then a court, if it come before the court can look at the order and it can look at the materials before the district judge and say he's got that date wrong. Objectively, you can say he's got that date wrong. He's made a mistake. On the face of that document, construing that document, he's made a mistake, so we can correct it.
I mean, can we postulate? Suppose it's a case management decision. A district judge lays down a timetable. He says, defence to be served by the 1st of December. And he actually meant the 1st of November or the 1st of January. He knows subjectively what he intended. It's not a matter of any other court working out whether he made a mistake. This is a question of whether he made a mistake. He knows he made a mistake. Why can't he correct it under the slip rule? I'm sure it happens all the time.
Because suppose he corrected under the slip rule, purports to do so, and he does it a week or two later. An application is made to have that reconsidered before the court. So the court is now looking at it objectively and trying to decide whether or not this was a case that fell within the slip rule.
Not sure how the court looks at that objectively. That's in the mind of the judge. The judge knows whether he made a mistake.
Well, my lord, but that's the point, isn't it? Because the slip rule is very clear. There is a judge cannot go back and change their mind.
No.
It's not giving effect to second thoughts. There's plenty of authority on that. But it is for a failure of expression in the judge's original thoughts.
So suppose there's a dispute about whether or not the district judge has changed his mind, or whether that was in his mind at the time. Is he called and cross-examined?
No, usually what happens is the application, if the judge doesn't correct it himself, the application's made to the same judge. He says, oh no, that wasn't what I meant, and changes it. I mean, it's as simple as that. And that's exactly what happened here with Justice Lewison.
To a certain extent, these are slightly... the orders we're talking about are the sort of orders that can be revisited any time anyway.
But I can tell you that the Court of Appeal regularly uses the slip rule to correct orders on permission to appeal, for example. There's some typing mistake. What happens is the court's stamp is applied and it says corrected under the slip rule. And I'm sure it happens in the county courts all the time too.
But it doesn't matter
But in your
whether you're strictly exercising a jurisdiction under 317 or under the slip rule.
But in your submission, it does matter in this case, because once Lord Justice Lewison put ground 3 in the original document, it's too late for him to come back later, as he did in September, and say that wasn't what I meant, as I told Mitchell Moores within 2 days. What I meant was it was limited to the bit of your skeleton in support of PTA, permission to appeal, headed beneficial interest. That's all I meant to give you permission for. Now,
he hasn't said that.
That is effectively what he has said.
Well, my lord, no, it isn't. I would dare say this court could ask him for a statement as to what his reasons were.
Let's have a look.
But my lord, if you look at the reasons, if one goes to page 81.
Paragraph 3. Cefn Coed was bought in the names of Mr. and Mrs. Williams and Dorian, and there was no express declaration of beneficial ownership. It is arguable the judge began from the wrong starting point. And then he says permission to appeal on grounds 3 and 5 is granted, limited to the question of the Dorian's entitled to beneficial interest. Now, I can see why both parties regarded that as not entirely clear, but it is possible to look at the material that was before him. The material that was before him included your skeleton argument in support of the application for permission to appeal, and that distinguished, it didn't, slightly unhelpfully, as Mr. James Pearce points out, didn't track the grounds of appeal, but it dealt separately from paragraph 17 onwards with partnership property, and then from paragraphs 26 onwards with beneficial ownership of Cefn Coed. And with the benefit of hindsight, it can be seen that what Lord Justice Lewison is doing is he's dealing with the partnership property question in paragraph 2, which he refuses, and dealing with the beneficial ownership in paragraph 3. Now that is probably the conclusion one would come to even if he'd never clarified his order, but he has clarified his order. And when one looks at the way in which he's clarified it, not just the email that was sent within a couple of days, but the more recent order, the one which is we are being asked to review, he says at paragraph 2, in black and white terms, to the extent that the formal parts of my order and paragraph 3 of my reasons refer to grounds 3 that may have created an ambiguity. If so, that was an accidental error. How can we possibly go behind his statement that was an accidental error? We can't, can we?
Well, my lord, first of all, unpacking that, if one looks at paragraph 2, it's quite clear he is specifically only addressing his mind to Crythan.
To what, sorry?
To the Crythan farm.
Yes.
Do you mean in paragraph 2 of the original?
Yes, yes. Tab 11, paragraph 2. Mr. and Mrs. Williams acquired Crythan on 25th of May. Conveyance contains an express declaration.
Can we separate that out to two things? There's one question of construction, which we may or may not need to deal with, but we don't need to deal with it if Lord Justice Lewison has corrected the order under 4012. Looking at the original order doesn't help us on what was in the judge's mind. As my lord has pointed out, Lord Justice Lewison has explained what he intended. He's able to judge that, we can't. And he's invoked 4012. How can we go behind what he says he intended?
My lord, that is why I say 4012 is not applicable to what has been done, because one gets in an impossible situation.
I don't see what's difficult about it.
Well,
The
my lord,
judge makes an order. It creates an ambiguity, as he himself has now recognised. And as we can all see, it's not perfectly well expressed. Now, as I say, that may be because of the way your skeleton argument was drafted, but it doesn't matter. What matters is that when he is asked for clarification, he says, that was a mistake. I didn't mean paragraph 3. Take it out. What's the problem with that? That is... I don't see why that gives rise to either a practical or a jurisdictional or a constitutional problem.
well, my lord, the practical problem is, well, we're already a long way down the line. The respondents accepted that we had permission.
Well, they didn't really, but I'm not sure that really matters at all.
But my lord, if one
the practical problem didn't arise if Lord Justice Lewison's initial clarification was accepted as what it said it was.
My lord, we'll come on to the 4012. The initial clarification, when it was made, is neither here nor there.
Why not?
Because, well, my lord, on the face of it, what is, at that point, it is a question of construction of the order.
Yes, but if a judge makes an order which is ambiguous and
My
not
lord, it's not.
clear, if a judge makes an order which is ambiguous and not clear, and one of the parties asks the judge to clarify what the order was meant to say, and the judge clarifies it and says, this is what it was meant to say, what is wrong with that?
There is no ambiguity on the face of this order. There is nothing to clarify. Because if one looks at paragraph 2, it is only dealing with Crythan for the particular reasons in relation to Crythan.
And you look at paragraph 3, and it's only dealing with the beneficial interest question, which has been identified as a separate question from the partnership property question in your skeleton. That's why it was ambiguous. I agree, but if you simply look at the box at the top, it looks as if you've got permission to appeal on ground 3, but when you look at paragraph 3 of the reasons, it creates an ambiguity.
Well, my lord, in
those circumstances, can a judge be asked to clarify what he meant?
Well, my lord, in my submission, there is no ambiguity here, because paragraph 2 only deals with Crythan for peculiar reasons applicable to Crythan. And he refuses ground 2. That is an exercise of the power to refuse on ground 2. Then he goes on to paragraph 3. And on the face of my skeleton argument, in order to determine the beneficial ownership of Cefn Coed, one had to decide both the partnership issue and the and in the alternative, the beneficial if it wasn't partnership property, the effect of the judge's decision. Those were two separate issues, both of which had to be decided on the face of my skeleton to decide the beneficial ownership of Cefn Coed. He only mentions the declaration of beneficial ownership, but then he goes on, permission to appeal on grounds 3 and 5 is granted in that paragraph. And then in the box.
And what meaning do you attribute to the words that follow, limited to the question whether Dorian is entitled to a beneficial interest?
Well, both those grounds go to the beneficial ownership of Cefn Coed. They don't add anything.
What limitation on grounds 3 and 5 do you think the judge was envisaging?
There is no limitation. There's no limitation in the box.
So the words limited to the question whether Dorian is entitled to a beneficial interest are inappropriate, because no limitation is intended.
Well, I think I have to accept they introduce an element of ambiguity, but they are not repeated in the decision, the effective part of the order. And as a matter, I say both both because it's not legitimate to look at the reasons, because what the court has done is what it said it's done.
Now,
well, why is it not legitimate to look at the reasons? The reasons are there to explain to the party, usually the party who's lost, why the decision has been made. It's always permissible to construe an order by reference to the reasons. There's a decision or assumption to that effect, which has been followed in this court can't remember the name of it, but it says you can always construe an order by looking, I think it's in the Privy Council, by looking at the reasons.
Well, my lord, all those cases are looking at the reasons given by the judges for an adjudication at a hearing in court.
So we're back to the point that this is not
Yes.
an
And my lord, I'm perhaps not as up to date as I probably am, and I haven't looked at all the judicial review authorities. But generally, if a decision is made in writing, it may be a matter of it is unlikely the reasons that are given either at the time or subsequently are going to govern what the administrative officer says he has done on the face of the decision.
Sorry, the administrative officer, I mean, here the judge says he's done on the face of the decision.
Well, my lord, the judge at the time gave his reason.
To be clear, when you say the administrative officer, do you mean Lord Justice Lewison?
Well, my lord, on my analysis, he is on the behalf of the court. He is exercising a power which is not in the nature of a judicial decision.
But we won't go back.
And my lord, that's almost exactly what is said by the court in North Range. And when they're discussing why you should have reasons for this sort of decision. And they refer to authorities in judicial review cases on whether or not reasons should be given for a decision.
So just break it down a little. We had this document. As my lord says, the Lord's Sumption passage in, I think it's sans souci, says you take into account reasons given when construing an order. You say that doesn't apply here because Lord Justice Lewison was making an administrative decision.
As Lord Halsbury says, this is not an order in the ordinary sense of the word.
And therefore, the ordinary principles of construction don't apply to it.
No, because it's doing something completely different. The reasons are ex post facto, subjective reasons to assist the party. There has been no adjudication, there has been no hearing. There has been, it is not a decision that binds the parties in the way that an adjudication would, or the court.
Well, why doesn't it bind the parties? It's a determination of the court, under the rules, as to whether permission is granted or refused.
Because it's not res judicata. And Phipson makes that clear.
I really don't think it's going to help us to go to res judicata. Just to be clear, because we need to move on to the next
well,
one.
my lord, that is at the heart of it. Is this an adjudication or not?
On the first question, which is, have you got permission? You say, as a matter of construction, it's clear that we were given permission on ground 3. And then you say there is no power to correct under the slip rule. If we were against you on whether or not the slip rule could apply, you would not have permission. Is that accepted?
That is accepted, and I'm then asking your lordships for permission. And I'm saying now is...
So that's question 2. Supposing that so far you have not got permission because even if you're right on construction, the order has been corrected, so you don't have permission to run the partnership asset point, then we're on to issue 2, which is, can you nonetheless ask us or ask the full court at the substantive hearing to give you permission on some other ground?
My lord, yes. And that goes, and then one starts with the practice pre-CPR, which was that the full court could always give permission, even if permission had been refused. One then has section 54, which says it's final when a court has decided. And up until 2016, one was entitled to bring it before the court. After 2016, you're no longer entitled as of right to bring it before the court. One needs to ask permission. Well, quick, my lord, assuming your lordship is not with me, that the exercise, that the power to limit permission is separate from the power of whether or not to give permission. Because the original submissions, as your lordship, my lord, Newey will recall, were that it's a binary decision whether or not to give or refuse permission. Once you give permission, then the Court of Appeal is seized of the matter, but there is then a power under the rules to limit the issues to be heard. If that is a separate power, then the usual rules 3.17 and other rules apply, and as Phipson says, one can always revisit an interim decision, and the full court, if it disagrees, can grant permission. If the court has already considered it once, then you're into grounds of whether or not it's proper to have another go at it. And that's Lord Justice Robert Walker in the
Yorkshire Bank case.
The Yorkshire case, and the cases I referred to most recently, Orgy and Nagra, very, very recent decision of this court that says those sort of principles only apply if there has been an adjudication.
Yes, but there was no question in Orgy and Nagra as to a distinction between decisions made on paper and decisions made in court. That simply wasn't an issue. The question was whether you could prevent someone from issuing a new claim form in circumstances where there'd been no decision on the first claim form at all. So I don't think you get any assistance from that case, or indeed from the case of mine which Lord Justice Coulson referred to in Wilson and McNamara, which was again a case where nothing had been decided at all. All I was saying was that Henderson and Henderson abuse is about reopening things that have been decided.
Exactly, madam.
But the point that is taken against you is Lord Justice Lewison has decided this. Now we have your submission that it's not that document of his doesn't count as an adjudication because it wasn't made in court. Suppose that's wrong, and that you can make adjudications on paper. Then where do you go from there?
Well, I think where you go from there is that you've established the principle that Parliament, by primary legislation or rules, can take the jurisdiction away from the court by delegating it to somebody other than a judge sitting in court. Now, and I was going to show your lordships the scheme of delegate.
Yes, let's have a look at the scheme of delegation.
Scheme of delegation, because there's a it's the notes to 5224. My lord, there's a reference to a notice entitled Judicial Authority of Court Officers in the Court of Appeal Civil Division. issued on the Judiciary of England and Wales website that delegates certain decisions to senior lawyers, who are of the Ministry of Justice, who are designated masters, and delegates other decisions to legally qualified or legal executives to exercise the powers of the Court of Appeal.
Now that one can follow, because we've seen from the legislation that the court consists of judges, and we can see that the court can act by one or more judges. So if you're going to entrust someone other than a judge to make a decision, then there has to be some sort of, you might call it delegation. But that's different from a judge making a decision.
Well, my lord, in my submission, a judge exercising the jurisdiction of the Court of Appeal can only do so sitting in court, and only in limited circumstances can the public be excluded from that court. That is so justice is both done and seen to be done. It is a fundamental constitutional principle of public access to the court. There is no requirement of any formal process to come into court. If a gatekeeper stands at the door of the court and prevents somebody coming in, the proceedings of the court are a nullity. In appropriate circumstances, almost certainly with legal representation, an application can be made to the court without any notice. Senior counsel can come into court and make an application to the Court of Appeal.
But this has nothing to do with our case.
It is, my lord.
We can see, for example, under 52(24)(6), that a party may request the decision of a single judge made without a hearing to be reconsidered, other than a decision made on a review and a decision determining an application for permission to appeal. So the rules specifically say you cannot ask for a decision determining an application for permission to appeal to be reconsidered under this.
My lord, that is because otherwise the judge would fall within, in my submission, the scheme of delegation, and that has to be expressly provided for in this rule. And the reason it's expressly provided for in this rule is that there are other provisions of the rules which deal with renewing or dealing with permission, questions of permission to appeal. And the question is there an ouster of what would otherwise be the Court of Appeal's substantive jurisdiction by a combination of the rules and the change to the rules in 2016, and it is only because of the change of the rules in 2016, and the decision which the single judge makes sitting in his room on limited material, making what is only meant to be a summary decision to shut out cases with no realistic prospects of success.
Can we just look at 52.6 in the rules? It says, in the case of first appeals, permission to appeal may be given only where there's a real prospect of success or another compelling reason. And then it says, an order giving permission under this rule or under 52.7 may limit the issues to be heard. So we know that it's contemplating that a permission to appeal order is made, which ties in with 40.12 applying, because that deals with orders. But it also says that the order can limit the issues to be heard. So the rules say it is possible to limit the issues to be heard. And then you don't anywhere find in the rules, do you, anything allowing you to reopen that decision except under 52.30. We see that it doesn't apply. 52.24 doesn't apply. That's specifically excluded. The right to an oral renewal has gone unless the judge directs that under 52.5. That's that.
Well, my lord, in my submission, the better reading of that rule, and consistently with the with the interpretation I put on 5230 is that 5230 is only concerned with refusals of permission that finally determine the appeal. Because 52.62 starts off saying an order giving permission under this rule. So that presupposes that the judge exercising the binary decision whether to give or refuse permission has decided to give permission. He can then turn his mind to whether or not he thinks all the issues are properly arguable, and he can limit the permission. But if that is not if that is not part of the decision giving permission to appeal.
Why do you say that?
Well,
Because
the reason I say it is that this court should construe strongly the rules against the ouster of this court's substantive jurisdiction.
There's not a question of ouster of jurisdiction. It's a question of who exercises the court's jurisdiction. There is no doubt at all that Parliament has said that rules can be made which limit the ability of someone to come into this court by requiring permission to be obtained. There is no doubt that rules have been made which says in general you do need permission, and rules have been made which says an order giving permission may limit the issues. In other words, may give permission for some issues and refuse permission for others. And the only question is, who makes that decision? And the rules say it's made by a single Lord Justice on paper unless they adjourn it into court. And they say you can't have that reconsidered, as you can with other rules made on paper. The only way, as my Lord says, that the rules contemplate that being revisited is under 5230. Now, you keep saying that this is an ouster of jurisdiction, but it's not. It's a distribution of the jurisdiction of the court in accordance with the rules to particular people, in this case, single Lord Justices. And I just don't accept that what's going on is some attempt to construe the rules in a way to oust the court's jurisdiction. The court has a jurisdiction which it exercises. It's just telling you how that jurisdiction is exercised.
Well, my Lord, I think the reason I say it's an ouster is that the court, a case where there's limited appeal, limited permission given, is inevitably going to come before the court at some point. The obligation of the court, when it is exercising its substantive jurisdiction in the appeal, is to do justice in the appeal.
No, to hear and determine justly and fairly those issues for which the appellant has permission to appeal, because you can't bring an issue to this court, save for very limited exceptions, unless you first have permission. So it's just incorrect to say the role of the full court hearing a substantive appeal is just to do justice in the abstract. It is to determine the issues properly brought before the court. And the rules say you need permission. If you don't have permission, you don't have an appeal.
Well,
if you've got a permission limited to ground 5, you don't have an appeal on ground 3, and the full court doesn't hear ground 3.
Well, my Lord, that's why one goes back to the language of Section 54, because you have a right of appeal to the Court of Appeal, a substantive right of appeal to the Court of Appeal from the High Court, and permission is only limiting its exercise.
I don't see the difference, Mr. Adams, between a statute saying you only have a right of appeal if you have permission, and saying you have a right of appeal but it can be only exercised with permission. It means the same thing. You have to have permission before you can exercise your right to appeal. If you don't have permission, you don't have an appeal.
My Lord, the reason there's a difference in my submission is that as the right of appeal to the Court of Appeal is a matter of law.
Where does it come from? It's statute, isn't it?
My Lord, I think there was a right of appeal before from the High. There was a right of it comes from the Judicatory Acts vesting in the Court of Appeal all pre-existing rights of appeal to the Court of Appeal. But I think by the Judicatory Acts because there were well-established rights of appeal to the Court of Appeal. And nobody is suggesting there isn't a right of appeal.
No,
under
the
Senior
Court of
Courts
Appeal,
Act.
the Court of Appeal, the Court of Appeal is a creature of statute. Now the Senior Courts Act, originally the Judiciary Act. Before that, there were different courts. There was a Court of Chancery Appeals, and there was a Court of Exchequer Chamber Reserved, and so on. But there was no single Court of Appeal. The Judiciary Act set up the Court of Appeals as a statutory body. It is vested by statute with jurisdiction to hear appeals. Statute has subsequently said you can only appeal if you have, has said rules can provide that you can only appeal with permission, in effect. Why is that not?
Well, my lord, there is a difference, and it's explored in the Yorkshire case, because under Section 8, the former Section 18(1)(a), there could be classes of case where there was no appeal to the Court of Appeal without leave, and that was a complete bar per Lord Justice Robert Walker in Yorkshire Hall. The difference about it being a procedural limitation on the right of appeal is that you have an underlying legal right to bring your case before the Court of Appeal. It is only a procedural filter, and the control of that procedural filter, the supervisory jurisdiction over that procedural filter, remains and cannot be ousted from the full court sitting in public, which is the ultimate arbiter of what issues need to be decided in order to do justice in the appeal, which you have the right to bring before that court. And there is a real difference, and that is why the wording of Section 54 is careful, because otherwise there'd be an attempt at the statutory ouster of the jurisdiction of the Court of Appeal. And the Court of Appeal is, as an appellate court, part of what used to be known as the Supreme Court, which exercises an unlimited sovereign jurisdiction. And it would be to accept that Parliament can oust that jurisdiction, in my submission.
And just to go over old ground very briefly.
But
Pre-2016, when you had this line of Court of Appeal authorities saying you couldn't go behind an order
adjudication in open court.
So I see. So on your case, that makes all the difference.
It makes all the difference, yes.
So you can, so to speak, oust the jurisdiction of the court if it's got as far as an oral hearing, even if it's before one judge.
Well, the court has done that. Well, you're not that subject to the reserved jurisdiction, but
No, well, it isn't, is it? Because post CPR, in the period up to 2016, there was no extra jurisdiction. A single judge in open court grants permission only on ground 1, not on ground 2. The line of Court of Appeal authorities says that's that. You cannot ask for permission on ground 2.
you can only give it under 5230.
Yes.
And that's the jurisdiction. And Mr. Justice Tugendhat, admittedly in its only first instance, says, well, there clearly is jurisdiction. I think the judge has got it wrong, so I'm going to revisit.
And let's leave that on one side, because there is a line of Court of Appeal authorities saying you cannot go behind the refusal on an oral renewal by a single judge of permission on ground 2. So why is that capable of being reconciled with your case?
Well, my lord, well, for the 2016 reason, all those cases were concerned with where the Court of Appeal itself, exercising its jurisdiction in open court, where justice is seen to be done, has heard argument on whether the issue is properly arguable and decided it's not. Unless something changes, or unless something's gone horribly wrong, that is an end of it. But the person who prima facie has a right to appeal to this court has had their day in court. They have appeared before the court. They've been heard by the court. and that issue has been adjudicated. And my lord, I've mentioned Phipson a number of times.
I have to say, I don't see that Phipson has anything to do with it, really. And insofar as we're concerned with questions of abuse, that's issue 3, so to speak. Maybe we should go to issue 3. So, supposing that it is the case that you don't at the moment have permission to appeal on ground 3, and supposing that this court has no power to give you permission to appeal on ground 3 in the light of what Lord Justice Lewison has done hitherto, where does that leave us? Now, I think you've taken issue with Lord Justice Lewison's description of chunks of your skeleton argument being abusive. And that, I suppose, ties in with the Phipson question of whether or not there's an abuse. But in a way, that doesn't really matter, because supposing that you only have permission to appeal on ground 5 on the way that Lord Justice Lewison has explained, it doesn't really matter whether you stick into your skeleton all sorts of things that are irrelevant to that. It doesn't really matter whether they're abusive or not, because the Court of Appeal at the substantive hearing will just ignore them, and the respondents will just ignore them, and they should just ignore them. So what do you say should happen if we get to that point where we think you haven't got permission to appeal on ground 3 and the court has no power to give it to you? What happens to your skeleton argument? I mean, we're concerned with an application to extend time. The skeleton argument that you asked to put in with the extension of time, for the most part, goes into matters which, on this view of the world, you couldn't run. It does have a section which corresponds almost word for word with the PTA skeleton, dealing with this point that you can run. Is it in those circumstances appropriate to stick by Lord Justice Lewison's order, giving you a chance to put in a new skeleton? Or should one simply say, look, now there's no point in this. There's no reason to give an extension of time in circumstances where the extension of time would be for a document that, for the most part, would be irrelevant and in any event would add nothing on what was relevant. What would the answer be?
My lord, I think the answer is if but that skeleton does not go in. And my lord, you have my lordship's primary submission in my skeleton argument that we didn't need to make an application for an extension of time anyway. It was we served it. There may have been a breach of the rules, but under CPR 310, there was no issue with it. But suppose this court affirms Lord Justice Lewison's judgment that we should consider putting in a replacement skeleton argument. We could just leave the PTA skeleton argument, which we're entitled to under the rules, which has all the arguments in it.
Yeah, okay. But on this thesis, most of the document would be relevant, but that's fine because the court would ignore all that was irrelevant, and the respondents would ignore all that's irrelevant. So that's fine.
In my submission, and my lord, Phipson goes to adjudication, not just abuse of process, and one of the examples it gives is of revisiting a permission to appeal.
But on this thesis, we're not. We think that there is no power to extend the grounds of appeal. So what do we then do about your application to extend time for the skeleton argument? Lord Justice Lewison says, well, you have a chance to put in another one. I suppose you have a choice as to whether or not you take advantage of that opportunity.
My lord, in my submission, what you must do then is look at my skeleton argument and decide for yourselves as a court whether or not the argument that is raised in it is properly arguable.
Well, on this thesis, we wouldn't be looking at whether anything was properly arguable, except to the extent you'd already got permission to appeal as corrected by Lord Justice Lewison. So we're dealing with about...
So this is on the basis of the Your Lordship's jurisdiction to consider it has been asked.
Yeah, absolutely. You haven't at the moment got permission, and the court, whether the two of us or the full court, has no power to give you permission. Therefore, most of the skeleton is irrelevant.
Well, my lord, you've already had my submissions on any basis, this court has jurisdiction as affirmed by Soffler under 5230. If it,
Well, there's no application under 5230.
well, my lord,
If
there
you wanted to make
wasn't in Soffler, and my lord, I make an oral application if technically I need to make it.
You need
But,
permission to do that.
My lord, that's what Soffler decided. You don't. It's just a question. That's just a question of process, not
well, there's,
jurisdiction.
I mean, this would be an entirely
And
new
I asked,
territory.
but my lord, if this court's jurisdiction has been ousted, then there's nothing I can do.
Yes, and I think my lord's question is, what do you want to do with your skeleton? Do you want to rely on your original PTA skeleton, or do you want to put in, which is what Lord Justice Lewison said, a revised skeleton limited to ground 5? Does it make any difference? I think the suggestion from my lord is
It may not make much difference. I think I'd like to think about that. But I should have an opportunity to do so.
I'm not sure why. I mean, you're here challenging Lord Justice Lewison's decision in circumstances where, on this thesis, you don't have permission to run ground 3 and you can't get it. Is there any basis for setting aside Lord Justice Lewison's decision?
Well, I ask some further time to put this. Well, my lord, I think the skeleton.
Attention, please. Attention, please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
That's merciful.
Attention, please. Attention, please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
As you say, Mr. Adams, it's 1 o'clock, as we're now reminded, perhaps anyway. So we'll break now, and we'll come back at 2 o'clock.